Welcome back to Law and Crime. I'm Lis Wiehl. Well, the David Copperfield case is now in a lunch break out in Nevada. This morning they had David Copperfield himself, the defendant in the civil case, on the stand. And he was taking a lot of questions from the plaintiff's lawyer about what he knew about the magic, not the magic on stage, but the magical things that were going on behind the stage. It got a little bit contentious there during that questioning back and forth. Sometimes it seemed like he didn't really want to answer the plaintiff's questions. Well, why would he? He wouldn't want to be helping the plaintiff's questioning at all. And so they're on a break right now. We're going to go back to Ohio in a few minutes to go back to the serial killer, alleged serial killer Sean Great's case. But before we do that, I'd like to introduce my guest here, David Eisbrouch. He is a personal injury lawyer in the New Jersey, New York area, and would have a lot of experience, not necessarily with David Copperfield himself or magic tricks, although I'm sure you do a lot of magical, not tricks, I would say, but a lot of magical things that happen in the courtroom. So tell me a little bit, if you would, about what your first impressions are of David Copperfield on the stand today.
Well, Lisa, thank you. Welcome. Thank you for having me, I should say.
You're very
again.
Welcome.
Interesting. Ben Morelli, whom I have a personal relationship with, Ben and I have worked together on many cases, is representing the plaintiff, Mr. Cox, in this case. He calls the adverse witnesses, the defendant's witnesses first. So his first witness on the box last week was the stage manager or the director of the backstage operation, and now he's called David Copperfield, who I believe testified last Thursday and now continued his testimony today. As you saw during his testimony, Copperfield was definitely a little vague and a little hesitant to answer some questions. Sure. Morelli was trying to get him to answer yes or no questions, which he typically will try to do. Copperfield didn't want to take the bait. He wouldn't answer anything yes or no. He was trying to structure his answers around what he wanted to say, what he wanted the jury to hear.
Well, he's been coached or instructed by his own attorneys, right? I mean, this is a this is a many multi-million-dollar case, and of course his own attorneys have instructed to only answer the question as narrowly as possible, not to offer anything up to the opposing counsel.
Well, it's interesting you said that. Yes, he's been prepped by his attorneys at length, and there are many attorneys at the defense table. If your viewers get a chance to view the defense table, there's 5 or 6 lawyers there because Copperfield's being sued personally, his company's being sued, MGM is being sued, the management company for the production is being sued. So you would think that he would be coached to answer these questions very narrowly, like we coach our clients as well. However, he's elaborating more than I thought he would have because, again, he's trying to structure his answers. So Morelli would ask him questions, is it yes or no, have you ever seen an audience member in flip-flops participate in this illusion before?
Okay.
Instead of saying yes or no, he'd come back and say, well, possibly, only if we felt that he was safe or she was safe walking in those flip-flops. Wasn't the question. Morelli didn't cut him off, but Morelli would come back 5 or 6 more times to ask the same question. People viewing this for the first time would think it's somewhat methodical or Morelli isn't scoring points. But trust me, he knows what he's doing. He's laying the groundwork. He's working with the adverse witnesses here. He's getting in what he needs to get in, and then he's going to be calling his own witnesses.
Right. And, of course, this is all playing in front of the jury listening to this. So I can't help but wonder if the jury isn't thinking, you know, first of all, you've taken away all the magic tricks. So that's
so no pun intended.
Yeah, no pun intended. So the magic's gone. But then you have somebody who looks like on the surface potentially to be obfuscating on the questions, trying to kind of dance around from the lawyer. Does that play to the jury as in, he's trying to
trick us?
Trick us.
Well,
right.
Well, it's interesting that on one hand, I think a juror would look at that. Remember, this is a very, very hometown jury here. David Copperfield is very well known in Las Vegas. This is a Las Vegas trial with a Las Vegas jury. Most likely, some of these jurors may have seen him before. I'm not sure in voir dire whether they asked that question. But some jurors, of course, would think, yes, he's being a little sketchy up there. Others they're trying to make, what I saw of Copperfield and of the stage manager's testimony, they made it very cut and dry. They tried to paint a picture that they are very careful and very diligent in inspecting the area where the audience participants walk or run or jog during this illusion. They're making it sound like they've taken this into consideration. They said there were over 50,000 of these shows with this illusion being performed, and this is the only person that got hurt. And Morelli picked up on that today as well.
Okay. And the fact that what I think they're really trying to get, or what certainly Copperfield wants to try to as much as he can, that, it's really without victim blaming in the sense that, hey, we didn't do anything. It's up to the victim, or it's up to in this case, the victim, but it's up to the people that are going through this magic trip to go as fast as they want or go as slow as they want. And look, all these people going through, and no problem.
Well, Morelli did speak about, how quickly do these people, and remember, this is an illusion where the audience starts on stage and then they have to be marshaled, so to speak, to the back of the auditorium, and by doing that, they have to actually go on the outside of the auditorium, through a side door, down an alley, back, and they're claiming that the lighting was poor, that there was debris on the floor. Now, Copperfield isn't admitting to any of this. His stage manager's not admitting to any of this. According to them, it was pristine. There were no problems. There were no issues. But the plaintiff is going to testify, and we don't know who else is going to testify on behalf of the plaintiff. They may have an expert in this field. They may have some other witnesses who work there, or former employees who work there, who may have somewhat of an axe to grind.
Right.
Former employees don't always make the best witnesses for the defendants.
Right.
Put it that way.
Interesting stuff. Well, we'll be following the Copperfield case. They're on lunch right now in Nevada. But we're going to go back to the Sean Great case in Ohio, and we're going to pick up on that. As you remember, this is the man who is being charged as serial killer with 23 counts, felony counts, 2 murder counts. This is a live feed we're going to go to, 2 murder counts, another kidnapping account. We have on the stand here, live on stand, we have Tina Schwartz. She is a social worker. We're going to go live to hear Tina Schwartz, social worker in Ohio, live on this case. We're still at the very opening here of the prosecution's case in the Great case. What we've seen now for the last hour or so is a social worker testifying. She was a social worker for one of the victims, one of the deceased victims. We've also heard on the stand here just one of the police officers who worked on the case. They're in a little bit of a break now. We'll go back live as soon as they have another witness on the stand. David, what do you think about this? I mean, we were talking a little bit about this trial and the amount of evidence against this particular defendant. It seems almost as if it's a long, slow, guilty plea.
Well, Lis, we don't know a lot about the defense case right now. They didn't open. We don't know if there's going to be an insanity plea or sanity defense. It appears.
Well, you haven't said that.
Appears by the evidence that he did confess to killing a minimum 2 women, kidnapping a 3rd. He has a long history, criminal history of 20 years. And I think another witness has taken the stand.
Yeah, let's go back live now to the Great case. This is in Iowa.
Ohio.
David, I'm curious of your thoughts, and we're listening to all this testimony about why you would think a case like this would actually even go to trial when you know that the defendant has actually confessed to not these murders, not the ones that he's actually being tried for now, but to actually 5 other murders. There's so much evidence here, so much physical evidence that we're just starting to get a sense of when you just, hear some of these witnesses start to testify. Why would something like this go to trial? Why wouldn't the prosecution and the defense come up with a plea? As we know, most cases plead out and don't even go to trial.
Well, Lis, the only thing I could think about with the limited information we have on this trial is it's about life or death. It's about the death sentence or a life sentence in prison. And obviously the prosecution and the defense could not make that deal prior to this, most likely because of the defendant's 20-year history, most likely because of the aggravated nature of this crime. that he had 2 women still in his house who he had killed. I believe that he had raped. He had a third that he kidnapped.
One woman, right?
Who testified, who escaped. I believe they'd be looking for the death penalty. Other than that, they might be angling for a insanity plea here, insanity defense, where he would mostly be institutionalized for the rest of his life. Other than that, I have no idea why they're trying this case.
Why wouldn't you, now, I come from a prosecutorial standpoint, that's usually my background. I'm not sure as a prosecutor I would have been willing to take the death penalty off the table in this case, unless I had the victim's family saying to me, for whatever reason, take the death penalty off the table. I don't think I would have been willing to do that. So I can see why, from a prosecutor standpoint, that it would end up at trial. From a defense standpoint, I can see why, there's really nothing else they have left to play with. I mean, death is really, I think you're right, death is really the only thing that's left on the table to keep this marching forward to trial.
And I just want to make a note that I would need to check this on a break, that there even is a death penalty in Ohio, because there's something sticking out. I'm remembering that if there's no death penalty in Ohio, then I would think they were only angling for an insanity defense here.
Well, and in federal court, of course, you have to put that up front. You have to tell the defense, if they're going to angle for that, has to tell the other side, the prosecution, that that's what they're going to do, and the jury has to know that that's what they're trying is an incompetency, or not an incompetency, but an insanity defense right off the top.
And actually, I believe the death penalty is on the table here, because I do remember reading some of the voir dires to the jurors whether they would be able to
death penalty qualified.
A death penalty qualified, yeah. So it's different states that I'm thinking of.
Right, and what death penalty qualified means, just to make sure everybody knows, and as you all know, is that once you get to that point where you've come through and you've said that the defendant is guilty, then the same jury, they can go back to the same jury and say, okay, and in sentencing, would you be able to say this person should be put to death? And you, this jury, would be able to say, yes, indeed, having found this person guilty, we would say that the person could be meted out to death penalty.
What should also be noted here, a little bit on the crass side, but still it is a fact, that even if you are convicted and sentenced as a death penalty, in most states it takes 20 to 25 years for the appeals to run before you're actually put to death. I remember in Florida there's a case that I was in the studio for a few weeks ago, and that was the case, but the defendant, again, was in his late 60s or 70. So there, a death penalty versus a life sentence, there really is no difference.
Well,
here you have a young man.
Right, and that's another reason, potentially, that for the prosecution to say, look, we'll take death penalty off the table, we'll save the state a lot of money, we'll just say we'll give you a sentence of life without the possibility of parole, and we'll say that, yeah, maybe he does have some mental problems, get him some help, rehabilitation somehow in the prison system.
This was also a case, I believe, where the defendant continued to speak to the press and possibly to the prosecutors after he was arrested in prison awaiting trial, and his lawyers couldn't even shut him up.
Right.
So,
well,
this guy likes to talk.
As we know, defense counsel cannot always, control or rein in their own defendant. That's not always possible to do because, looking at this case, I think all of us sort of wondered, why is this even going to trial? Why weren't they able to, strike some kind of agreement? Why are they putting the state through all of the expense and trauma and the victims' families through all of this? Because don't forget, let's not forget about the victims' families here. They've got to go through this. They've got to hear about their daughters, their loved ones, having gone through the torture, everything, all of the horrible stuff that happened to them. And they've got to hear that, and they've got to watch this person in that courtroom day after day and see that versus just taking a guilty plea and having it over with.
Agreed. And all counts.
Right. All right, 23 counts. So let's go back right now to that courtroom where we are having a witness sworn in. I'm not quite sure who it is, but we'll find out for just a second and give that information right back to you in the great case. And here we go. Right back.